Our first case this morning is 2016-56, Lyons versus City of Alexandria. Mr. Pershing.
Mr. Pershing, whenever you're ready, please.
Good morning, Your Honor. May it please the court. The City of Alexandria gave two inconsistent, even contradictory explanations for delaying Mr. Lyons' promotion in this case. The first one, the one that was voiced at the time, was a supposed doubt about his qualifications, given that he had to take the written test for the paramedic position half a dozen times till he passed it. He did pass, of course, but Mr. Schultz said in an email of October 11th, while the delay was going on, that he was going to, by my direction, he was going to delay, he was going to hold up Mr. Lyons' assignment to an internship until people who qualified after him were placed. That doesn't fit the facts, of course, because it's hard to imagine that Mr. Lyons' qualifications, which did not change, would suddenly evaporate or disappear the objection that Mr. Schultz professed in that October 11th email. That's on Joint Appendix 336, by the way. He said he would consider Mr. Lyons only after certain other later qualified candidates had been placed. The second explanation for the delay arose only during the litigation. And it says, oh, well, we didn't actually delay or hold up Mr. Lyons' application to be a paramedic, to have an internship at all. We didn't hold that up deliberately. In fact, it was sort of a logistical happenstance. It was an accident arising out of a practice we had to assign people to internships on a first come, first served basis by shift, only by shift, as it were, a kind of numbered place requirement for internships that you could get only when an opportunity arose on your shift. That too doesn't fit the facts. The record shows that.
Let me ask you,
sorry, Your Honor.
Mr. Pershing, was there any challenge raised to the validity or the relevance of this test?
We didn't brief it.
Any challenge raised to the test itself?
We did not below. Of course, I came in only on appeal, but the court is, of course, aware, as Your Honor's question reveals, it. The court is aware of the sordid history of these tests and the possibility that they are racially disparate in impact at a minimum. I do not know.
I know. At a very general level, that could be true, but I'm talking about this test in particular. Was there any challenge? I didn't see that there was any challenge raised to this test.
That's right, Your Honor. Our client did not object to the test itself. He took the test as many times as he needed to in order to pass it. He became as qualified as anybody else. The administrators of the test did not say your qualifications are diminished every time you take the test till you pass. And if he had failed it a sixth time, he would simply have had to take the course again. It's not as if it was some kind of lifetime.
Well, okay, if there was no challenge raised to the test, and if it's undisputed that he failed the examination 5 times, that's not helpful to your case, is it?
It's not helpful, but it's not hurtful because the qualification remained the same, and the doubt could have been erased if the doubt that Schultz said he harbored in that email would not have been erased within a few months if it had any weight. That, it seems to me, is an inference totally open to the jury about that explanation for the delay. You don't just, his qualifications didn't change, and so how could it be if the doubt had any merit or any was really of any weight?
Well, if the test is relevant and he's failed it 5 times, is there any comparative that any other person that failed it 5 times?
I don't think there was. I think he had to work very hard to pass that written test, and he did so. He even paid for a remedial course out of his pocket. But I don't think it matters, because as he came in to the pool of eligibles for the internship, his qualifications then remained the same until he was assigned one. And yet the claiming this doubt as a reason to intentionally hold him up, that seems...
Well, you know, one thing that's interesting to me is may or may not be analogous to a bar examination, but many law firms will pay for an individual to take the test once. And some particularly generous law firms would pay for an individual to take the test twice. And a lot of law firms, if you fail the test the first time and certainly fail it the second time, would say goodbye. And so the analogy may not be perfect, but it surely is relevant.
I don't disagree. I don't.
Well, just, hold on just a second, and I appreciate it. If it's true that the city paid for each attempt here, and that they continue to support him through all of these failures, and as I understand it, afforded remedial training to assist him in passing. It seemed to me that they were being pretty supportive to assist, to stay behind him through all these failures, to assist him in passing. How is that discriminatory?
I don't disagree, Your Honor, that the record shows us that Lyons tried more than anybody else we've got record of to pass that test and did finally pass the test. And I totally recognize the court's point that it doesn't show discrimination in and of itself that they allowed him to keep taking the test. I should point out that he did pay.
Well, but wouldn't that show a supportive outlook toward this plaintiff? And eventually he did pass the test and they stuck with him, and then he did eventually get his paramedic internship. So, I mean, is this a question of no good deed goes unpunished?
No, I don't think so. And I'll try to explain why. I agree that the giving of the chance to retake the test in and of itself does not show us that there was a discriminatory animus underlying the holdup that resulted after that. It does not appear to me that Schultz, the fire chief who didn't like that it had taken Lyons several tries to pass the test, is not apparent from the record, and I don't think the jury is required to conclude that therefore there was no discrimination. The problem here.
Can you tell us what is the purpose of the test in the first instance?
Well, it's one of the qualifications, Your Honor. It is a nationally administered test, NREMT-P for paramedic, the National Registry of Emergency Medical Techs. What is the qualification to take the test?
What qualifies an individual? In other words, could the city say, I'm not going to pay after the second time?
I think so. And my understanding of our record is that Mr. Lyons paid for a remedial course. I don't know if he paid for later test-taking fees later. But what I do know is
from that perspective, the city chose to pay, and at the end of it, once one is certified, is there anything to indicate that the number of times you took it would be a qualifying difference as to whether you will be able to move to the next level sooner or later?
That's my
Is there any indication that those who do particularly well, or those who are more qualified, or appear to be more qualified, at least in terms of basic abilities, would get priority over those who were perhaps less qualified?
A perfect question, Your Honor. The answer is no. Once you pass the test, you're on the same footing under any policy or practice that I've seen as everybody else who's passed the test. And the administrators of the test.
Counsel, why doesn't the email that you quoted suggest to the contrary, right? That's an email that says, listen, because it took the guy 5 times to pass, right? We're going to put him at the back of the lawn. I mean, I'm not sure if that's a good idea, a bad idea, right? But it doesn't seem an unreasonable line to draw to say, if it takes you 5 times to pass, we're going to put you at the back of the lawn.
Well, Your Honor, I don't disagree that it might be plausible as a reason to doubt the qualifications of someone. I don't disagree with Judge Wilkinson's idea about the bar exam, but the problem is that the explanations changed. Schultz's doubt, as the court pointed out in that October email, was superseded.
But I want to follow up there in terms of the email. Was there any indication of this before? No. It was approached with him. In other words, that's a fair determination that you can say if you take it multiple times, you're going to lose priority. But was there any indication of that before this instance at all? And then upon obtaining the priority, it seems as though if you take a test 5 times, you may take the bar, and maybe there are those who are different on it. You take it and pass the first time, that indicates a high degree of proficiency. But the fact of the matter, if you do something over and over, let's say 4 or 5 times the bar, you would think that person probably has a pretty good knowledge of the law because he's done it a lot of times. But the idea here is that the ultimate purpose of the test is it is a foundational prerequisite before you can go to the next level. And except for that email, there's no indication that you're going to not get priority. It's sort of like taking the bar. Once you pass the bar, there's, other than maybe the law firms make a difference, but in terms of being a lawyer, the state certifies you just like the guy who took it 20 times or 1 time and you took it 5 times. So you are the same lawyer as the next one. So, it may differ from job to job insofar as a law firm, but just like here, if he wanted to get certified by someone else or some other entity, they may say, well, we're not going to do it. You took it 5 times. But here you are within a situation where it is like the bar. Once you take the bar, you are made once you pass it, no matter how many times, you're made a lawyer. That's the bottom line. The idea is not to get a job. Getting a job is another thing. You're made a lawyer. That's the promotion you get, is now you're a lawyer just like everybody else. And no one goes around wearing a sweater or anything that says I didn't pass the bar for 5 times or that kind of thing doesn't come up. So that's and even though that seems to be the issue here, their rationale, what seems to be more interesting in this case is, does it in fact trigger a Title VII a situation? In other words, that delay between the time that he actually gets past this test and then that delay, is that an act under Title VII that should qualify to take an action?
Thank you, Judge Wynn. I think the answer to that is of course it does, because there was a monetary consequence. There was a pay loss that Mr. Lyons will never be able to recoup. The question whether there was adverse action, whether there was an effect on a term, condition, or privilege of employment, I think is not something that need to detain the court in this case. It's a fascinating question. That's why Amicus United States is here today, and I'd be happy to address it after they have said their piece.
Can you address just briefly before your time is up? We spent a lot of time talking about the qualification piece, but what struck me is the hardest for your case is not that, but is the organization by shift and the lack of evidence you put on to challenge that. Can you talk to me about why I should look past the by shift organizational system?
Yes, Your Honor. The answer is that it doesn't fit the facts. It turns out the record will tell us that at least one of Lyons's shift mates was leapfrogged over him for an internship that he qualified for earlier. That's all right. So I
understand that argument, and I'm not going to debate it with you, but I understand that argument. Is that the only argument you've got on this issue?
Well, it raises the question whether the explanation was pretextual, and even the shift of
but that issue, it's the shift made. What I want to make sure is that I'm not missing an argument that I couldn't sort of pull out of your brief. I understand the shift mate point, but is there another argument, or is that argument the sum and substance of the by shift issue?
Your Honor, I say I have about 4 seconds. Shall I answer? Please. The city claims that even that leapfrog by Kilner is a product of a kind of logistical happenstance because by the time that the Kilner opening arose, Mr. Lyons had already applied to transfer off that shift, but they didn't even tell him that the opening had arisen until after Kilner filled it.
So they tried to, when Mr. Lyons wanted shift A, they tried to accommodate him there. That request was granted. My difficulty is that you're taking an employer who's accommodating at various steps along the way, particularly with taking the test repeatedly, paying for the test. And then when it comes to the shifts, they tried to continue the accommodative attitude and saying, you want the shift A, the request is granted. I don't know what the shifts have to do with. I suspect it's hours, but it seems to me that perfectly plausible that you might have some more training officers for one shift than you would for another shift. People have preferences, but the point was that he wanted shift A, and
Your Honor,
once again, the employer is accommodating and granted him shift A.
Your Honor, with respect, I think it's a little bit like the taming of the shrew. No, we will not make our noble Kate have.
All right, I'm sorry, but you've got some rebuttal time. Can we hold off and hear you on rebuttal?
Of course, Your Honor.
Okay, thank you. All right. Courtroom deputy, who is up next?
Ms. Esau.
All right. You want to set the time in? Okay. Please proceed.
Good morning. The district court's ruling was correct for 3 reasons. Mr. Lyons failed to state the required elements of a disparate treatment claim. He failed to adduce any evidence in the record to establish that his race played any factor in any of the decisions that the city made. And he also failed to meet his burden of establishing pretext. The district court ruled correctly that he failed to establish a prima facie case. Mr. Lyons, when you look at him vis-a-vis his comparators, the record is very clear that there were reasons for the fact that the city made the decisions that it did. With regard to the 3 comparators that Mr. Lyons identified, the 3 white comparators, Mr. Consul was on a different shift than Mr. Lyons. Mr. Kilner, there are clear non-discriminatory reasons why he was placed in an internship before Mr. Lyons. And the same is true for Ms. Renner. And there's also another key fact in the record that Mr. Lyons is not focused on with regard to the comparators. As you all well know, in the Fourth Circuit, it's very clear that Mr. Lyons has to show that these individuals are similarly situated in all respects. Mr. Lyons does not focus on one particular individual, and that is an African-American comparator, and that is Mr. Alexander Lee, and that is, you can find this in the joint appendix at 104 and 89. But Mr. Alexander Lee shows unequivocally in the record that the city did not take race into consideration with regard to the internship program. Mr. Lee passed the exam after Mr. Lyons. He was placed in the internship program before Mr. Lyons on January 23, 2018. So this actually belies any claim that Mr. Lyons has asserted that the city's treatment of him was racially motivated. And Mr. Lyons does not address this issue at all in any of his papers. So the district court opinion indicating that Mr. Lyons had not adduced any evidence that his race was a factor is clearly correct in this regard. In addition to that, there's
Let me ask you with regard to the similarly situated one. Everything you say may be true, but is there not also evidence presented by the plaintiff that it was a first come, first served basis? And given that evidence, why is that not an issue of fact on that?
Well, yes, Your Honor, there are a couple points on that. With regard to the first come, first basis, it's not inconsistent with the defendant's testimony regarding the shifts. And then also Mr. Lyons, when he argues the first come, first basis, first come, first served basis argument, he's relying on Lisa Simba for that testimony. And it's undisputed in the record that Lisa Simba was not a decision maker with regard to the internship program. So that is not an admission that can be used against the city. And Mr. Lyons himself admitted that Ms. Simba is not the one who made the decisions with regard to this program.
One thing that, excuse me, Judge Richardson, go ahead.
Would it matter, counsel, if it wasn't hearsay? So Ms. Simba's statement, obviously the plaintiff didn't appear to call Ms. Simba as a witness. And so the only thing we have from Ms. Simba, obviously, is hearsay. And so it can't prove the truth of the matter that's asserted. And so does that make a difference for you in evaluating Ms. Simba's testimony?
Yes,
Ms. Simba's alleged statement?
Correct. It's our position that it is hearsay, and therefore it's not admissible. And in addition to that, we don't believe it's inconsistent with the testimony in the record. There's no indication that it's inconsistent with our position that it's shift-based. For example, when Mr. Lyons switched to the A shift, the testimony in the record, undisputed testimony in the record, is that he was placed first on that shift. So being first come, first serve on a shift is not inconsistent with the testimony in the record.
I mean, what I'm saying, what I'm thinking is, if first come, first served, that begs the question of who is the first come. And the first come can be the person who's qualified by passing the test. And so I'm just not seeing that a first come, first served policy is inconsistent with the idea that the first come is the first person who is qualified by passing the test. That's one question I had, and the other one was, I'm not sure exactly how the plaintiff went about proving that there was some sort of first come, first served policy, because there's certainly no written policy to that effect. And he was never deposed or cross-examined. Chief Andrews or Mr. Schultz on this supposed first come, first served policy. But apart from not being able to show a first come, first served policy, let's suppose there is a first come, first served policy. Well, the first come, logically enough, would be the first person who was certified by having passed the test. So there just seem to be multiple difficulties here with what's being alleged.
And one other point I want to raise here is that when we say first come, first served policy, and this is the point you're raising, Your Honor, because there was no deposition, and when Mr. Lyons asserts that there's this first come, first served policy, we have no context because there was no deposition on this issue.
Of course, the whole purpose of summary judgment is to determine whether there's an issue of fact. And, you know, my friend Judge Wilkerson does pose a reasonable interpretation of it, but that's not conclusive and will not the ultimate determiner of fact here. And if he puts forth evidence or in the testimony that from the first come, first served meant, and even his own statements to that meant that those who were qualified or those who passed the test would go first. And even if you passed the test one time, the question is someone who took 5 times had already passed it before you passed it. That's the question. You know, I don't think it's the situation of someone passed it once, the first, and then sometimes much later, after 5 tries, he passes it. That's not the situation here, I don't think. But correct me if I'm wrong. But I think what it is that it took him 5 times, but then there were those who then took it 1 time or 2 times afterwards who got priority in doing it. And if that's the issue, then he is saying that first come, first serve means, you know, he passed before the others did it for the 1 time. Is that right?
Your Honor, it is correct that it took him 5 times to pass the test, and he is claiming that others who passed the test after him did get into the program. Remember, Your Honor, because of the timing of when he finally passed the test, there were other people who were ahead of him because it did take him so long to pass the test. So they were already further along.
Is that the issue? Is that the issue here? Is he complaining about the ones who were ahead of him who passed it before he did, or those who passed it after he did?
I think he's complaining about both. But I think the 3 we're talking about now are the ones. Well, address
the ones who passed it after he did, because that would seem to be one in which, you know, that first come, first serve would seem to play. For those who passed it after he did, even though it took him 5 times, were there individuals who actually got priority in terms of being able to move to the next level?
When you say the priority, I would not use the word priority. These are individuals.
Well, let's. I don't want to get into the semantics of it. I simply want to just ask the question. Those who came after him, is that the complaint here for that group that came after him? That's the complaint, as I understand here. And there were those who came after him who were then given the opportunity to move to the internship program. Is that correct?
That is correct. And those are the ones that because of their shifts and other reasons that they were placed in an internship program. And that's also the individual, Alexander Lee, who's also African-American, who was placed before Mr. Lyons.
Now, I know we're going to hear from the government on it, and it sounds like the defendant, or at least the plaintiff, you know, I thought he should have addressed it directly. And that is a question of the adverse action here, which is, I guess, more of a legal question in terms of would such a delay for an internship program that is sounds like to me it is a prerequisite before one can be promoted. Is that an ultimate employment type decision, cognizant under Title VII?
Not under the law in this circuit, Your Honor. In this circuit, it has to be a significant detrimental effect, and I take the position that it's not under the law in this circuit.
In which case are you relying primarily on for that?
Primarily James versus Uzalin, Your Honor. And then also, there are a couple other cases as well, but primarily James versus Uzalin.
Are there, I mean, I'm not certain that we reached this question, but if we reach the question, what is the best example you've got, not of the principle that is a significant detrimental effect, but instead that the reduction in pay or the losing out on the increased pay doesn't qualify as a significant detrimental effect, right? I mean, I understand the argument, and I think the delay by itself might not be sufficient, but there was also a reduction in pay as a result, or a failure to get an increase in pay. I'm not trying to make a judgment about the phrasing there, but why wouldn't that qualify as a significant detrimental effect, even with that standard?
Well, I believe here it's a question, sort of where do you draw the line? He did eventually, of course, get the position. But, just sort of another example, let's take a law firm example. Let's say you have a group of, law firm summer associates. You have a group that starts in June. You have another group of summer associates that starts in July. There's a 1 month delay there between the group of summer associates.
But as long as they're both going to work for the same 10 weeks, that wouldn't be a reduction in pay, right? Because it's a finite time period. It's a little bit different in the context where you say somebody's going to get a pay increase at a certain time, and we're going to delay that by 3 months. That pay increase is perpetual, right? So it's not the summer associate is for a set period of time, but where what we're talking about is a permanent increase in pay that he forewent for, a month or 2 months or 2 days. I don't know, whatever the delay ultimately ended up being.
Well, and the example I was going to give is I was going to say actually that the one group of summer associates was going to actually have a shorter period of time. The group that was starting later was going to be a shorter summer associate program.
No, we've walked into this business on the bar exam and lawyers. This is not the same situation. I mean, not at all. I mean, of a summer associate as opposed to someone who has been working in the fire department, and then you have certain prerequisites that allow them to advance, and one of them is taking a test. He passes the test. You get hung up on how many times he took it, but he passed it. And that seems to be the prerequisite, not the number of times. Doesn't seem to factor at all until his email pops up. And then once he passes it, the question then becomes, is it an adverse situation, to delay him and allow others who passed it after him to move to the next level? I mean, we can talk about law firms and interns all we want, but we're not going to get anything out of that because there are just too many differences of law firms, and there's all kinds of things. I have law clerks and things, and they take different rules. But we're talking about a situation that if it fits within the context of Title VII, the question here is whether this is under Title VII and an ultimate employment type action here that for which you can find an adverse discriminatory action. Do you disagree?
I think on this record, the court did not actually have to reach that decision. It did not have to determine whether or not it was an adverse employment action.
Well,
I understand that. I understand that if you proceed in that way, and I agree with Judge Richardson that if you make up your mind on the other things, you don't have to get there. But for someone perhaps in my position, I'm asking the question that if you do get there, and it may well be that the court will decide you don't have to get there. I'm not quite there. I think this issue is squarely before the court. and is a very focal point of this case.
And our position would be that, you know, the denial here of the promotion or the delay, excuse me, of him getting this position was not a final decision. I think for an adverse employment action, you need to have a final decision. He did eventually get the position.
Well, let's suppose we just assume arguendo. I know you're not conceding the point. I think you have a good argument, but let's just say we assume arguendo that there was an adverse action here. My basic question on the merits is, where is the discriminatory animus? I mean, you can be dissatisfied with the place in line or whatever, but where is the discriminatory animus? Because, as I point out, the evidence in the record that I read was that they were rooting for this individual. They were cheering him on. They were paying him to take the test over and over. They, I think, gave some assistance with respect to it. They wanted him to succeed. They didn't want him to fail. And when he wanted a certain shift, they granted his request for the shift. So how does the fire department get hung with the program of being a discriminatory entity, when all along it seems to me that they're on the side of this individual? They want him to succeed, and they did indeed give him the paramedic internship that he sought. I mean, it's like sometimes if this entity is discriminating, then it seems to me you could find discrimination almost as a matter of course. And I thought when I read this record, they want this individual to become a good contributing member of the paramedic division of this fire department. They want it to work out. And yet here they are being hauled up as harboring discriminatory animus. And that's just the ultimate, the adverse action point to one side. I certainly understand your argument in that. But I just thought on the merits, they were on the side of the plaintiff. And they thought he could be a good contributor. And they wanted him to be a good contributor, and they gave him the internship that he sought. This is not a bad actor.
Do you agree with that? Do you agree with what Judge Wilkerson just said?
I do, Your Honor.
In other words, your statement is that the fact that the city supported him in doing this, there cannot be discrimination if in fact there's evidence that they supported him, but they supported white workers more so. You think Judge Wilkerson's scenario fits as a matter of law, that just by supporting him, they cannot be discriminatory insofar as allowing others who are in a similar situated position to be promoted on the basis of race? Is that your statement?
Well, Your Honor, I don't agree that that's what Judge Wilkinson said. Here on the record,
well, wait a minute. Hold on. I want to backtrack that because I'm there. I heard that. And I heard it said that the fact that the city supported him, wants him to be promoted, shows no racial animus. Is that correct?
What he said is that the fact that they supported him.
Let's not be argumentative. Let me make sure do you agree with that statement? That fact alone
that they supported him, the fact
shows
that they
there's
supported
no
him
racial. No
The fact
racial
that
animus.
That is not what I said. What I'm saying.
But then,
is,
Judge Wilkerson, I would ask, would you restate it? I do not want to misstate what you said, but it sounded to me very much that is what you said. But
Well,
if you
no.
did not say it, in fact, I would like a clarification.
What I am saying is that the supportive attitude that the department took for the application here, resulting in backing him at every step of the way, helping him with the request, helping him with the test. I'm just saying that in the summary judgment calculus, that ought to weigh in terms of not finding an issue of tribal fact. I was not announcing any per se rule. I was talking about the facts in the summary judgment record, and I stand by what I said, that the facts here and the supportive attitude that was taken toward the application here should weigh in the summary judgment calculus as to whether there is an issue of tribal fact. And I think it's a good thing in my judgment to help to support employers who are in turn supportive of African American workers. And I think that's a good thing, and it's something you want to encourage. And that's what I think the record indicates.
Well, Judge, I accept what you're saying, and in that light, that's a different type of statement than to say that because they supported him so even vigorously with all of this, there's no racial animus. I just disagree with that. I agree it can be some evidence or maybe a factor to consider as to whether summary judgment, but when you're looking as to whether there's disputed information, if there is evidence that yes, they supported him, but on the other hand, they did so in a manner that discriminated against him because they promoted or advanced others who were in a position who happened to be of a different race, and it did so on the basis of race. But Judge, I would like to finish if it's okay. And the reason I want to finish because I think that's a very critical point. And I do not want to leave this discussion feeling different. And I'm glad you clarified where you went with that. But my point being, and what I think the clarification is that doesn't really solve this case, the fact that they supported him, because there is more here that is at least being alleged and evidence put forth here. And with that additional evidence, that's a consideration, but it is not determinative. You can support black workers as much as you want. You can go up and hold up signs, says I'm all for black people, and then at the same time do something completely discriminatory or to deny them promotion opportunities. That does not deny them a Title VII action, at least in my point of view. And I think you are agreeing with me on that point, except that you may not think that the second part is there. That is that he's shown that there is something else there discriminatory.
Well, all I'm saying is that I was speaking to the facts of the case and the facts in the summary judgment record, and I was simply making a statement that I thought that the actions here of the individual defendant was supportive, and that should weigh in its favor in the summary judgment calculus. All right, let's hear who is up next here.
Ms. Baldwin.
Ms. Baldwin, we'd be happy to hear from you.
Thank you, Judge Wilkinson, and may it please the court. Anna Baldwin for the United States as amicus. The court has had a lot of discussion about, the first ground on which the court granted summary judgment this morning about the genuine issue of material fact as to whether the delay was based on race. As the court's aware, our amicus brief is just on the legal standard for the second ground on which the court granted summary judgment, saying that there was in this case no adverse employment action. And that holding is clearly wrong. And to see how it's clearly wrong, imagine that if the factual record in this case had been, there were clear direct evidence where you had a decision maker saying, Mr. Lyons, we are not going to give you this internship assignment and the accompanying pay raise that it comes with for the next 5 months because of your race. We're going to promote all of the white workers first, right? If there were clear evidence of discrimination, clearly the separate element as to whether there's an adverse employment action, which is just a shorthand for does the discrimination regard the plaintiff's terms, conditions, and privileges of employment, clearly that is at the heartland of the kind of claim that should be actionable under Title VII. So, there's been some discussion here again about the fact that this involved compensation. So, that makes the question even more clear, but the United States involvement, and we're glad to be able to address the court this morning, is to focus on the significant detrimental effect requirement that this court has required for a number of years in terms of showing adverse actions, and to encourage the court to turn back to the plain language of the statute and analyzing whether in fact there's been an adverse employment action and whether there is an actionable Title VII claim. So, under the plain language,
do we even need to reach this question? We can assume there's an adverse action and then proceed to the merits.
Certainly the court, could resolve the question in that way. I would encourage, and the United States would encourage, more importantly, the court to reach this question and address it, because this is a case where you see the way in which the significant detrimental effect is effectively having a poisoning effect on the case law, where, actions, it's allowing courts to
Can I ask the question, Ms. Baldwin, because I didn't exactly understand this as fully, but it seems like to me you're telling us we need to overrule our prior precedent. You're saying we need to turn, the language I think you used was turn away from the significant detrimental effects test and go back to the text of the statute. And that might be a totally legit argument, but you understand that we're a panel, right?
Absolutely, Your Honor. I understand that this court sits as a panel, and I know that this court, it's the United States position, and it's in the briefs that we've attached in Forgus that we've told the Supreme Court, in fact, standard is wrong and misreads the Supreme Court's decision in Ellerth. I know that this panel can't reach those questions, but what this panel could do is nonetheless decide the claim and whether there's an adverse employment action, first by analyzing, does the discrimination that's alleged regard the terms, conditions, and privileges of employment? That doesn't conflict with any prior precedent. And just as an example of this, the Sixth Circuit recently—
wouldn't that listen, I totally understand your argument that suggests that the significant detrimental effects is not the right standard, right? But that's the standard we have to apply, isn't it? I understand you want to get away from that, and I understand why you want to get away from it, but I don't understand how I can do that as a member of this panel. I have not just one, but multiple prior panel decisions saying that question, the statutory question you're asking, ask whether there's a significant detrimental effect.
Sure, Your Honor, that's this circuit's test. The United States could imagine an opinion that, analyzes in the first instance, does it regard the terms, conditions, and privileges, and then, sort of explains, and also it does meet the significant detrimental effect. The court—
So the United States is asking us to ignore our prior precedent, but then just sort of pay lip service to it at the end.
No, Your Honor.
It seems like an odd position for the United States to be taking, that this panel should do something that is forbidden by our precedent, which is to overrule our prior decision. I understand. Maybe you want to say, I just wonder, you want to say take it en banc. Maybe that's one story, but it's just odd for me for you to keep telling us to ignore our prior decision.
Sure.
In the context that we've got.
Your Honor, as an example of a way I think a panel has threaded the needle, and I'm certainly don't mean to be telling the court to ignore your prior precedent, and it certainly is the case the United States would support an appropriate case en banc hearing, but the Sixth Circuit has similar precedent about having to show, a materiality impact. And Judge Sutton, in the Threat versus City of Cleveland case, recently analyzed, sort of by a first instance, returning to the text of the statute and then explaining the way that the sort of adverse employment action doctrine had gotten away from that and still paid service to the fact that he was writing as a single judge and that the Sixth Circuit had precedent on this case. But in looking, that case involved the city of Cleveland had a policy that you couldn't have a shift of all Black captains who served together. And the question was, well, our shift assignments, is that, a materially adverse, impact? And so the court said, look, clearly a shift assignment, and it's a racially discriminatory shift assignment. We're going to analyze that in the first instance as to terms, conditions, and privileges. So I would just point the court, that is the kind of decision where the court could make an impact in this law, the law where the Sixth Circuit has done similarly. But the point here is, I think it's important for the court to begin to give some kind of guidance, even sitting as a panel, to the lower courts, because whether this was an adverse employment action it's not a difficult question. Imagining that there was a clear, showing on discrimination, of course.
Even if we were going to take the test, so significant detrimental effect, you might be able to fit what happened here as a significant detrimental effect. In other words, I don't think I know you want to swing for the fences, but you don't even have to go that far. You could just say, look, if you're deprived of pay or whatever, that's a significant detrimental effect. But the point is, you just seem to be asking us to reach for things that we don't need to decide. And at any rate, unless someone else has further questions, I think your time has expired.
Thank you, Judge Wilkinson.
All right, if anybody else has any further questions, I'm happy to let those be asked.
No.
All right. Mr. Pershing, I think you're up, and I think you have some additional time here.
Thank you, Your Honor. First of all, the point the court was debating a few minutes ago about the ultimate discrimination question, that is a question for the jury. I think our precedents in this circuit settled the point. Prima facie case plus some evidence underlying the explanations that were given, pass summary judgment. That's Dennis versus Columbia Colleton. That's Merritt versus Old Dominion Freight, a case that the opinion was authored by Judge Wilkinson. In that case, you had shifting explanations. You had one explanation that arose after the litigation began, and you had some evidence undermining both explanations, including the very fact that they shifted. And that is our law in this circuit. It says if you've got that, if you've got shifting and inconsistent explanations, which we certainly have here, that passes summary judgment. The court can't simply cherry pick and set some elements of a factual dispute equal to zero and then pretend there is no dispute. So I think that's first of all. Secondly, I don't remember if I mentioned this, but the shift of origin.
I don't think there's a shifting explanations. There's simply alternative explanations. And they said you did this for multiple reasons. First, if there's a first come, first served policy, that has to be that the first come is the person who first passes the test. And then second of all, there was a business about the number of available people on each shift. And you say there's shifting explanations, but that's really different from alternative explanations, each of which may hold water in its own right.
Indeed, Your Honor, and they may be multiple plausible explanations, but the court below is not supposed to cherry pick them and decide them. That's for the jury to do. That's what our cases say. I don't dispute that there are plausible reasons why some of this might have happened.
But the Celotex decision indicates that plainly the plaintiff bears the burden of establishing from the summary judgment record an issue of triable fact.
Right.
And on Celotex, that is your burden, in addition to the ultimate burden of proving the discriminatory animus.
Right, and that's a trial burden. But the key thing is that our cases say, here's how you pass summary judgment. you raise a fact issue showing that the prima facie elements are present and that the explanations are undermined, the legitimate non-discriminatory reasons are undermined, and that they shifted is also probative of pretext. I don't think the court can get around that below.
Well, why wouldn't you undermine them by deposing or cross-examining Mr. Andrews or Mr. Schultz?
And that could have happened, but in this case, we have a fact issue without that because Captain
That
Simba
would
has an email.
But wouldn't taking that deposition be the quickest way to undermine it?
It might, but we have ways to undermine it without that deposition having been taken. The email by Justice.
You're saying that the city presented these shifting explanations, and yet the people who would be in possession of those explanations were never deposed or cross-examined during the course of the deposition.
Well, Your Honor, I can't.
Their testimony as to the explanation would have been the most relevant. They were never deposed, and you do have an obligation to create an issue of triable fact.
Right, and I think a triable fact issue is present regardless of whether these people were also deposed. Let me explain. Captain Simba has an email where she says, this is first come, first served. The city wants to raise a sort of invisible ink argument saying that she must have meant first come, first served by shift. We know that that is not the case because of Ryan Kilmer being leapfrogged over, a shift mate being leapfrogged over, so the explanation is undermined. As soon as you show an undermining, you create a fact issue that the court can't simply pretermit. That's our argument. You can't simply cherry pick the facts. The other thing is on adverse action, its innocuousness is not the same as its adverseness. And I think the court below may have run into that trap. But I would say that here, the plain monetary loss gets us beyond any dispute about whether the action was adverse. The question is whether the logistical accident of first come, first served by shift that they claim, or the darker explanation obtains, and that's a jury question. But let's remember that at the time that Ryan Kilner was put into that slot there, that internship slot, the Lyons was never told until after the opportunity disappeared that he could have had it. And the city knew perfectly well how devoted he was to getting that internship. They didn't want him knowing somebody else had been put there. They didn't want him asking about it. Your Honor, see, my time is up, but there's plenty more to.
Thank you very much. If either of my colleagues has questions, we'd be delighted to wait. Judge Wynn, do you have any more questions? I can't hear you.
No further questions. Thank you.
All right. I'd like to thank all of you for your arguments. We unfortunately can't come down and greet you and shake your hands, but that doesn't mean we're any less appreciative. So thank the three of you so very much, and let's proceed into our second case.
Thank you.
Second case is 2020. Hello. Oh, I'm sorry. I apologize. Mr. DeSantos.
All right. Mr. Callows, who is up first?
Mr. DeSantos is up first, followed by Mr. Callows.
I'm sorry, who first?
Josh DeSantos.
Oh,
Lucas.
Mr. Dos Santos, we'd be happy to hear from you.
Thank you, Your Honor. May it please the court, Josh Dos Santos on behalf of the United States as amicus. The Medicaid drug rebate statute is specifically designed to get state Medicaid programs the best deals on prescription drugs. And the statute does that by requiring manufacturers to agree to provide Medicaid programs with a rebate. And the rebate is calculated based in part on the manufacturer's best price. Now, for years, CMS has interpreted that phrase, manufacturer's best price, as meaning the price, quote, actually realized. That's the phrase used by the manufacturer, inclusive of all discounts and all rebates, and including discounts and rebates to more than one entity. And this requirement stems from the rebate agreement that manufacturers must agree to in order to have their drugs eligible for coverage under Medicaid. And it stems from the 2007 rule that CMS adopted. And that rule in particular specifically rejected the interpretation being advanced in this case by defendant. And here I'd like to read from the preamble where CMS addressed this interpretation that defendant is raising here. It says, the commenter stated that the statute is quite clear defining best price as the lowest price to any wholesaler, etc. Commenters argued that if Congress had intended anything other than a customer by customer analysis, this is defendant's argument here, of separate prices, the statute would have combined each customer with the word and instead of the disjunctive or. And then this was CMS's response. We do not agree with the commenters. And a bit later on, it said, best price is disjunctive.
What about the language of the statute, counsel? That's the thing. I mean, how do you get away from the language of the single price, the singular price? And then there's the word available, which would indicate an actual price rather than a hypothetical price. And then it talks about any wholesaler, retailer, or governmental entity. So when you combine the singular price with the textual word available, and then put in the word any wholesaler, doesn't that suggest an actual entity rather than a hypothetical entity, which is what the aggregated or average prices would seem to lead you there? In other words, I've got a real question over how you deal with a number of words in the operative section as a matter of law.
Okay, Your Honor, let me address that head on and try to clarify for you. So CMS's interpretation is a reasonable one of the statute for several reasons. Now, I think you can break that down into looking at the text and then looking at the structure and context of
okay, even if I concede all of that to you, which I do not, you say that's a reasonable one, but I would think that the defendants here was probably the best as a viewer of textuality. But let's suppose you're right, hypothetically, and that the CMS interpretation is reasonable. But suppose also that the defendant's interpretation is reasonable. Are we going to allow these claims to go forward on some sort of Chevron basis? Is that the test for fraud?
No,
I mean,
no, Your Honor. And I think here,
this counsel, there's a lot of room for Chevron. I'm a supporter of Chevron in those contexts where it applies. But to say that reasonable interpretations, two reasonable interpretations, or even one arguably reasonable interpretation in one, which the statutory language suggests is the best, how does that form the basis for fraud?
so Your Honor, let me take that in pieces. So the allegation here is that the defendant knew or that it was on notice that the 2007 regulation was imposing this requirement, and did that with the requisite knowledge under the False Claims Act. Let
me just ask at least a question from the perspective of where you're going with this. I don't read the district court opinions having actually gotten to this question. It looks to me as the district court determined that the defendant here position was not objectively unreasonable and never really answered that question in terms of the falsity of these statements. I mean, so even where we're going now, whether it's Chevron deference or whether the interpretation, none of that, I don't see that in the district court's decision. Am I wrong on that? Or
No, that's correct, Your Honor, and that's the
So you are arguing something the district court never got to.
Right, and that's
because he relied upon this term objectively unreasonable in terms of the defendant. And when Judge Wilkinson mentioned textualism, and where is that word in the statute, objective, in modifying reasonableness?
Right, Your Honor. It is.
It's in the Safeco decision. That's where it is. It's in the decision of the United States Supreme Court. And in the Safeco decision, we can affirm on any basis that's evident from the record. And the statutory text here is something that's evident. But you ask, where is this? The whole objective reasonableness standard derives from the Supreme Court's Safeco decision. And there have been a slew of circuit court decisions that have followed in the wake of Safeco.
Your Honor, I do want to point out.
Well, wait a minute. I want to make sure we stay on my question. I understand Safeco used that term as a footnote at the very end of the opinion that goes there with it. I'm with Judge Wilkinson. It's out there, but there are many decisions on the other side too. My question is, where is it in the statute? I don't care who said it. Where is it in the statute?
Well, Your Honor, you're correct. The statute does not import the rigid framework that the defendant here is trying to say is required by Safeco. Safeco involved a different statute with different text, different case law, and different history, and importing a rigid framework to limit the three different knowledge provisions in the False Claims Act is a fundamentally flawed enterprise. As to falsity as well, Your Honor, there is no qualification of objective falsity in the statute. The Supreme Court made clear in Escobar that the courts should not impose additional limitations on the falsity provision of the False Claims Act.
Well, look, you can look into, if the statute doesn't define the word, you can look into its ordinary dictionary definition, and you know that. And the ordinary dictionary and the common connotation of the word falsity is one where there's a false fact claim. It's not a difference of legal interpretation. It's a question of, excuse me, counsel, it's a question of whether the claimant is claiming the things with respect to materiality. I mean, with respect to materials or with respect to personnel, or we're claiming something factually that was known to be false. But all I'm saying is that I think you've got multiple problems here. And the first one pertains to the word false and its ordinary definition. And the second goes to scienter and what the Supreme Court has said under the Safeco case. And I don't think we are any more than the other circuits. 3 or 4 of them have applied the Safeco decision to their ruling. And I don't think that we're at liberty to disregard that.
Your Honor, the 11th Circuit...
All I'm saying is, counsel, there's a problem with respect to the underlying question of what falsity means. And even if you get past that, there is a question of what scienter is.
Your Honor, there was a lot in that question, and I do want to take it in pieces. As to falsity, this court has already held in the Drakeford case, that when the question is a defendant's compliance with the law, that is an objective question. That is an either-or proposition.
But let me move it even further. Judge Wilkinson indicates you can go to the dictionary. Is that what we do when under this particular type of act here with false claims? Or do we look at any type of common law? Is there a federal common law definition of false and fraudulent claims? And can you have a false claim if it is a subjective situation, reasonableness? Does it have to be objective? Or can it not be subjective also?
So, Your Honor, the common law of fraudulent misrepresentation, which the Supreme Court has looked to when interpreting the False Claims Act, under that common law, it was and is possible to have a misrepresentation based on an ambiguous statement. And it is true, Your Honor, that looking to the common law is a good place to start when interpreting the False Claims Act. And you see that what Congress did was it separated out the requirements of the fraudulent requirement of fraudulent misrepresentation into false and knowledge. So
that's why you have under the common law that you have items beyond this where misrepresentations, omissions, and opinions and medical judgments can also be actionable under the Federal Claims Act. So, I mean, that's part of where we are now is in trying to cabin this definition. And when we come up with a term like objective unreasonableness, the fact that courts continue to repeat it in a context that I do not believe it was used in Safeco in that matter doesn't make it part of the statute, because ultimately we're looking at the statute. There is no objective qualification in that statute. And then to go to the definition under the federal common law, you don't find it either. So I mean, the repetition of it issued mostly by lower courts, and we can disagree in terms of the applicability of Safeco, but it does not mandate this outcome in this case, at least in my view.
Your Honor, that's correct. And as to the Safeco issue, I'd point this court to the HALO decision, where the Supreme Court addressed the Safeco argument and said, look, it doesn't apply here because this statute, it was the Patent Act. This statute has different text and it has a different history, different case law. That's the same situation here.
I haven't seen you speak in terms of the statute. And I pointed out 3 words in the statute. The singular was used as a price, and they were talking about any wholesaler, retailer, which suggests an actual entity. And they were talking about a price available, and you're talking about a hypothetical price and one that's not available. And you're talking as if the statute had been written in terms of average price or as opposed to an actual available price. And I don't think the statute was written that way. And then when you combine that with the Safeco decision, you've got a lot to overcome.
Let me start with the statutory piece that you're referring to, Your Honor. When you read through the statute, you pointed out that the words are singular. A lot of the defendant's argument rests on that. But we know from the Dictionary Act, we know in general, that Congress can include the plural in the singular, that based on the context, this can be read to mean any wholesaler, retailer, or collection of them. And the context is what's going to guide you here. And there are several pieces here. One is that the word any can be very expansive, as we know from other cases like Smith v. Berryhill. The other is you can see from the history here and first provision where it says that, where Congress said that the best price needs to be inclusive of discounts, free goods that are contingent on purchase requirement, volume discounts, rebates. You get the clear picture that Congress is trying to capture the waterfront here. It knows that sales can be complex. It knows that there could be rebates to one entity, like an insurer, but then there's a different volume discount to the wholesaler. And I also want to point out the structure here. Remember that the way that you calculate the rebate is by looking at the difference between the average manufacturer price and the best price. And defendant agrees that the average price does require stacking. It would be very odd if the average price were routinely lower than the best price.
Thank you, counsel. You asked for 5 minutes. We've given you 6.5. And if either of my co-panelists has a question of you, I'll be happy to let you speak further in response to it. Judge Richardson, do you have a question?
No question. No question, Joe.
All right. Who do we have after that?
Your Honor, Joe Callow, also on behalf of the plaintiff relator in this matter.
All right. Well, we'll be happy to hear from you.
Thank you. And I'd like to pick up on Judge Wynn's question about the statutory interpretation. The first and fundamental problem with what the district court did is it didn't interpret the statute. It said there's multiple different interpretations and I'm not going to pick one. And under Drakeford and under Mallory, that's the first and foremost problem for reversal. The court is required to interpret the statute. And we believe that the interpretation is guided by the CMS regulations and guidance that Mr. DeSantis discussed. The statute.
The problem I have is if you're there, we know that Chevron applies and these reasonable interpretations. You only get to Chevron if the statute is ambiguous.
Yes,
and what the defendants are claiming is that you can't string us up for treble damages, say that we have committed fraud when under Federal Rule of Civil Procedure 9, it's not supposed to be that easy to prove. And you can't string us up for treble damages and attorney's fees and this and that, and in some cases put our very existence on the line and turn people out on the street because they lose their jobs due to these incredible FCA awards. Now, I'm all in favor of an FCA award where there's fraud committed. But by the very act of going into Chevron, you're conceding that it's ambiguous. And the idea of imposing these kinds of sanctions on defendants on the basis of ambiguity it's really unbelievable to me that we would do something like that. It just seems to me shorn of the elements of due process, which requires something other than under Chevron we think something is ambiguous. And the implications of this are quite devastating when we are saying any ambiguous interpretation is a basis for an FCA claim. That goes a long way.
That's right. 3 points in response, Your Honor. First and foremost, I don't believe the statute is ambiguous. I believe the language of lowest price available from any manufacturer, that any means all, when you look at 1 USC 1, a common dictionary definition of any, and multiple Fourth Circuit opinions that talk about the fact that any means all in multiple statutory contexts. So I believe that the court should interpret the statute to be unambiguous and find that the interpretation that both the DOJ and the relator proposed is plausible, as the DOJ noted. Second, if you find it to be ambiguous and look to that guidance, we're not guessing as to what that guidance is. There is guidance in the rebate agreement, which has the force and effect of a statute. There is guidance in the comment and notice period in 2007. And there is specific notice and comment in 2016 that specifically says, when you give a rebate to 2 different entities, you combine them for actual price realized under the regulation. That confirmed the consistent policy over time without a change in rule regulation.
You can still take advantage of the lowest price given to an actual entity. You can still do that. But the word any, it can mean, it actually cuts in your favor, only not in the way you think. It can be any wholesaler out there or any retailer out there or any governmental entity out there, as long as it's an actual entity. And that's what the word any means. And you, as I say, you can, of course, without the aggregated rule that you're arguing for, you can still take it. The government is still able to take advantage of the actual. The defendant wants a higher best price. And you can take advantage under this statute of a lower best price, a low price, as long as it's actually available.
And Your Honor, when the court interprets the statute, the question of whether or not an innocent party is being held into a False Claim Act case goes to the subjective nature of intent, whether it's reckless disregard, deliberate ignorance, or actual knowledge, and that's a factual issue. And this court has repeatedly said it protects defendants by rigidly holding to that standard.
How do we get the subjective business in light of the Safeco decision?
Well, Drakeford and Mallory from this court specifically talk about the need to allow juries in the trier of fact to determine whether or not a party has the appropriate knowledge, reckless disregard, or has been warned away, all of which are fact issues. Both of those cases talked about the advice of counsel and whether or not a good faith interpretation that was given to them by counsel was appropriate for that knowledge requirement.
Well,
aren't you going to make us an outlier here? There's something like 4 different circuits in the wake of Safeco that have said this is not a scienter is not a matter of subjective good faith. It is a question of objective reasonableness. And there are 4 circuits that have gone in that direction. And aren't you making an outlier of us?
I am not, Your Honor, based upon the Drakeford and the Mallory decisions that this court's already issued and the decisions of the 11th Circuit. But even under that Safeco analysis that you're describing, all of those courts talked about the importance of guidance. And if there is authoritative guidance to a defendant, then the decision is different. Because
I want to address the Safeco decision itself before we walk down this path. It was a decision that dealt with an entirely different statute, which was the Fair Credit Reporting Act. This is the False Claims Act. The Supreme Court has made it clear that context matters. And so if we're going to try to import this common law definition of recklessness or from the federal from the Credit Reporting Act, the Federal Credit Reporting Act, into the False Claims Act, that's an entirely different issue. And the court itself acknowledged, and they said it. They said construction is often dependent on the context in which it appears. The Federal Credit Reporting Act is intended to promote fair and accurate credit reporting. The False Claim Act is intended to prevent fraud. 2 different things. And to take that context and walk down the road into a totally different statute is really taking Safeco out of the realm in which it is. You need only go to the next line when you go to Halo, where the Supreme Court did speak to it and show you that. Escobar shows the same kind of limitation. The Supreme Court recognizes that the False Claim Act has a different purpose, and we go back to the statute. Congress has a role here. Courts have weighed in on this thing. They come up with this objective of unreasonableness business, not even in the statute, and yet want to say textualism here, textualism there. But when we go right to the statute, we know exactly where it is. And if you don't like it, go to the federal common law. And you go to the federal common, you don't have to go to a dictionary, go to the federal common law. And it's right there that allows for this expanded definition of what a fraud is. If we go down this way that has been indicated we're going, ultimately we're going to gut this False Claims Act of the very purpose that Congress enacted it for. And import into it what the court feels like it should be, perhaps under the Fair Credit Reporting Act. 2 different contexts, and the Supreme Court has acknowledged us time and time again. Listen, follow us, but do it in context. And the context of this is different. And there are different courts who have gone different ways, maybe in a dissenting opinion, maybe other ways. But there are some very thoughtful judges who have gone the other way on this issue, and for good reason. And they are following the textualist approach here of going to the statute and saying there is nothing in this False Claims Act that talks about objective unreasonableness into it. And then they look into turn what fraud is, then you can go into the common law to determine that.
Your Honor, may I briefly respond? I know my time is lost.
Sure.
Please.
No, I mean,
Judge Wynn, I completely agree. And I think the context matters, both interpreting the best price statute as well as the False Claim Act. And there are a number of decisions and a number of thoughtful analyses that talk about the exact difference that you described. The False Claim Act is the federal government's primary tool to uncover fraud against the United States. It is the single most important tool to do that. And in order for it to succeed, courts and judges have to follow the statute and this interpretation of the statute.
What you might do, Mr. Callow, is when you come up for rebuttal, you might address the cases from the 3rd, 5th, 8th, and 9th circuits, which have imported the FCA's, have imported Safeco's reasoning into the FCA's parallel scienter requirement. And it seems to me that the statute has plenty of room to convict people or to make them the object of a civil judgment. There are plenty of cases of fraud that don't involve sort of borderline and guessing games as this one. But if you would wait until rebuttal, Mr. Cowell, I know you feel passionately about your case. I know Mr. Dos Santos feels passionately cases, and I totally respect both of you for that. And I think you'll have some time on rebuttal. And is it time for Mr. Elwood to give his argument?
Thank you, Your Honor.
Judge, I just want to add one other little point that I think in looking at this, there are elements in terms of the falsity in scienter. And sometimes we convolute those and conflate those issues. And I think it's important for you to parse those out to make sure what we are talking about, particularly with Safeco, is it in the context of scienter? Is it in the context of whether we are dealing with a the falsity of it?
All right, thank you, Judge Wynn. Do you have anything further to ask of Mr. Callow?
I do not. Thank you, Judge.
All right. Mr. Elwood?
Thank you. May it please the court, John Elwood for Appellee Allergan Sales. This court can affirm the district court's judgment on any one of the 4 grounds outlined in our brief, demonstrating that the judgment below is correct. First, because the Medicaid rebate statute does not require the aggregation of discounts to separate entities. Second and third, because the objective reasonableness of that position makes it impossible for relator to plead either falsity or scienter. And fourth, because relator failed to plead fraud with the particularity required by Rule 9b. Now, I'd like to address a couple matters right out of the gate about the matter of scienter and where exactly this comes from. Judge Wynn, the Supreme Court, the scienter involved in the Fair Credit Reporting Act is exactly the same as in the False Claims Act. It's knowing or reckless. Knowing includes deliberate ignorance. So it's exactly the same mens rea required there as here. The Supreme Court said, you know, you can't even get to recklessness under common law. And the Supreme Court in Escobedo said you use common law if a term is undefined, as it is. Recklessness is undefined in the False Claims Act. You can't get to recklessness unless it's objectively unreasonable. And I want to read to you something from the government's own brief in that case, which is that it said, well, it's on page 23. I don't know if I can find it.
Let's be clear where you got that from. Is that footnote at the very end of Safeco?
No, this is from the government's brief, Your Honor, on page 23 of the government's brief in Safeco, where it said, unless the defendant was objectively reckless, you don't even inquire into
I'm more interested in what the Supreme Court said.
And this issue was directly in front of the Supreme Court. You can look at the argument transcript.
Interested in what the Supreme Court said, not a brief that the government submitted to anybody else. I want to know what it was the Supreme Court said in Safeco.
Well, the Supreme Court said it on page 70 in a footnote, but this argument was definitely in front of them. They spent a lot of time on argument discussing it. It would define.
So they put it in a footnote at the end of the opinion, and that makes it, you feel like they addressed a matter that was directly in front of them on that particular issue in a footnote at the end of their opinion.
That is exactly right, because it was not a central issue to this, and it was.
I'm not saying it can. I'm just saying it's interesting that you highlight that was really what it was about.
It was important.
And yet they put that in a footnote at the end, and then they also indicate that context matters. There's no question of that. It's in there that says that, you know, and important is context. And I would take it your position is that the context of the Federal Credit Reporting Act is essentially the same as it is for the False Claims Act. I take it you have to say that, don't you? Given the opinions.
I would say
you have to, don't you?
I'm sorry. There's a buffer here, so I can't tell when you're speaking and not.
Well, now the question is, given the Supreme Court said that context had to be there, that you have to accept that the context of those two statutes is the same.
I would say it applies a fortiori in the fraud context, because we're talking about treble damages, a finding that you are a fraudster, that you have defrauded the federal government. And I think that the argument that you can just do this based on, you know, whatever, I mean, the government talks a lot about post hoc rationalizations. You can have an objectively reasonable interpretation of the statute, and you can be found to have violated it later because somebody comes up with a better argument than the one that you already had. And it was important enough, Your Honor, that the government addressed it in its own brief, and it was the center of its argument, oral argument at court. It said only if the defendant's failure to comply with the law was objectively reckless would it become necessary for a court to probe the defendant's subjective good faith. So the government thought it was important enough to put it in the brief and to make it part of its oral argument. And I think that applies a fortiori here when you're talking about a fraud statute, not just about, making credit reports fair, but whether or not you are a fraudster.
Why wouldn't we read that footnote in the context of the Federal Credit Reporting Act instead of in a broad sense that it applies everywhere? And Judge Wilkins indicates there's a whole bunch of courts out there. But really what we have is two circuits have applied that safe code definition of recklessness to the False Claims Act in passing. But you got the Halo decision that follows there, and in which the Supreme Court cabins this. It makes it clear that there may be a different context here.
Your Honor, I would disagree. In addition to the super value case from the Seventh Circuit, which happened just recently, we have Shimon versus Equifax, 2021 case from the Second Circuit, Long versus Timmy Hilfiger from the Third Circuit, and Levine versus World Financial Network, which before Phelps, the 11th Circuit said, if it's objectively reasonable, you don't even talk about subjective intent. So there's all that. Now, Halo, I'm a little bit interested to hear both these parties making so much of Halo, because neither of them thought it was important enough for them to raise in their opening briefs. The only brief the government has filed in this case doesn't even mention Halo. And there's a reason.
But when you talk about something that wasn't important to raise, we spent a bit of time talking about statutory interpretation. I think you got to agree the district court really never got there on that.
I don't think
we spent a lot of time talking about that.
Well, I don't think, as long as you can get to objective reasonableness, you don't need to get beyond that. But if I could just talk about Halo.
But I want to deal with that and make sure we understand it. It didn't get to that statutory interpretation, did it?
It didn't ultimately conclude one way or the other, although it said that our reading was the plain and natural reading of the statute. So
I understand that's boilerplate language right there. I mean, the plain and natural. But I'm talking about in terms of the basis. The basis of it turned upon is determination that there was that the decision of the defendant here, Allegan, I guess, was not objectively unreasonable. And once it got there, that kind of ended it, didn't it?
But I think that's an appropriate thing to do. For example,
I'm not saying it's inappropriate. I'm just saying as a matter of what we are reviewing. That's what I'm trying to get to is it stopped there. We can spend all day long talking about statutory interpretation. District court didn't get there. So if we find there's a problem there, that's something for the district court to do, not us, right?
I don't believe so. I think to begin with, there was enough statutory interpretation the court got to the position that our position was objectively reasonable, in addition to the plain and natural reading of the statute. But in addition to that, I mean, this court can always talk about what the statutory interpretation of the statute is, and I would be happy to get there. But as far as Halo goes, I think it's important that, again, neither party thought it was important enough to raise beforehand, and I think there's a reason for that. The court was interpreting Section 284 of the Patent Act, which the Supreme Court emphasized involved bad faith infringement. And so the court said, in the context of such deliberate wrongdoing, it is not clear why an independent showing of objective reasonableness would be a prerequisite to enhance damages. It didn't walk away from Safeco. It just said it matters differently in a case that involves whether or not they involved wrongdoing, whether you'd already.
Let me go with your definition of Safeco and its effect on Sienta. And if we read it that way, focus on this recklessness, what do we do about the other two standards? What do we do about actual knowledge and deliberate indifference type?
Well,
I mean, essentially, you just collapsed it into one. And I mean, in a tort sense, when you're dealing with recklessness, that's different than actual knowledge of it. I mean, that is almost like a lesser type thing you come to. And I'm confused on that aspect of it. You got Congress that articulates three different separate means of doing it. And if you read Safeco in the manner that's done here, which I contend you should not, then it allows you to read two of those three Sienta standards right out of the Fair Claims Act, of the False Claims Act. And so how do you respond to that?
I'd say for the reasons mentioned in the government's brief in Safeco on page 23, you don't even get to those other mental states unless you can say that the statute is objectively unreasonable because, Your Honor.
You certainly don't if it is the Fair Credit Reporting Act, but we're talking about the False Claims Act, for which you've got those different standards there. Congress didn't need them, because if you're going to come and deal with the recklessness, you can just throw them out.
Your Honor, the mens rea in the Fair Credit Reporting Act is exactly the same. It's knowing and reckless. Knowing automatically has deliberate ignorance built into it. That's mens rea law 101. And so it's exactly the same standard. And when you're talking about a legal question, this was an argument that this came up at oral argument in the Safeco case. You can't say you really know what the law is if you have an objectively reasonable position and you don't have authoritative guidance. You may have an opinion, you may have a guess.
So at the end of the day, you're saying Congress just created 3 redundant requirements here then? Didn't need all this. Congress wasn't trying to broaden the definition of fraud here. You've collapsed it down into one nice little package here.
In the mine run of cases, all 3 would have a role, but where we're talking about where the uncertainty is about a legal issue, yes, it does collapse it exactly with an identical mens rea in the Fair Credit Reporting Act provision. But in addition to that, Your Honor,
the point is, with a scienter, a requirement of let's put knowing and deliberate indifference to one side, but you can't be reckless if you have an objectively reasonable position as a matter of law for your position. That's not recklessness, and that's the gravamen of the Safeco decision. That when we were interpreting scienter, recklessness cannot be derived from an objectively reasonable position. I mean, if that is so, if it can be, you just overturn eons of law, and but that's the basic point of Safeco, and that's the whole thrust of things. It's almost a due process matter, and that is you cannot subject companies to financially ruinous sanctions, and they really are ruinous for the company's very existence on the basis of, for example, negligent behavior. And this isn't even negligent. And the point is here, not only is this an objectively reasonable standard, and I think when Mr. Dos Santos was talking about Chevron, he made it clear that there was ambiguity here. And when you look at the statute itself, there's not just one word that makes your interpretation reasonable. It's 3. It's the word any, it's the word available, and it's the fact that the entities involved are expressed in the singular, and the fact that the word price is expressed in the singular, and you put all that together, and you get the idea that they're talking about an actual price available. And that's different from an average price or an aggregated price or something that is purely hypothetical. And your position, and the district court says, my colleague Judge Wynn says, oh, just boilerplate, said this was the most natural reading of the statute, but it's a perfectly natural reading of the statute. A perfectly natural reading of the statute. If Congress wants to say you've got to go that best price means aggregated discounts, that's up to Congress. But it sure as heck didn't say that, at least in unmistakable terms here, that would seem to me to lay a proper predicate for imposing, to repeat myself, ruinous financial awards upon company after company that is making claims based on objectively reasonable beliefs.
I agree with you, Your Honor. You will not be surprised by that. But I just want to point out also, in addition to, they're asking for a price that no party receives. It's not available from the manufacturer to anyone. No party has ever received that. And that's not
So
even,
I don't understand that. I don't understand that. First of all, as I indicate, I think that recklessness covers different conduct than actual knowledge and deliberate indifference. But if you look to these facts here, CMS makes a rule. The client disagrees with it. And then you do a data audit of this thing to identify rebates stacking. Then you eliminate most of the scenarios and you put language in the contracts to make sure that happens. But it didn't do it for your favorite customers. Why is that not knowledge for violating the law?
Your Honor,
It's squarely so. It's squarely so. If the idea being is if you can't have actual knowledge and be reckless. And in other words, you have to be, at least from what I understand your proposition, is you got to be reckless before you can have actual knowledge. That doesn't follow. You can have actual knowledge and not actually have to be reckless. You can be deliberately indifferent and not actually have to be reckless. To collapse it in is judges rewriting statutes to fit, or perhaps what Judge Wilkerson alluded to, that maybe trauma-owned companies or whatever. I don't know. But that's not our job. We follow what Congress has set forth here clearly. We got a clear example of conduct. It had to know that when it made those distinctions for the favorite customers, it knew it was violating the law because it had already disagreed with CMS, took its data, did it for some, not for others. And as a result, the allegation is that the United States and the citizens of this country are being deprived by this falseness up here that results in $680 million being deprived of the government.
If I could have time to give two answers. First, it's not collapsing this across the board. It's when there is an objectively reasonable legal interpretation. There's really no such thing as actual knowledge that your interpretation of the law is the wrong one, or that you're being deliberately ignorant. Secondly, as we argued in our brief, if you look at page
so to follow that point, you can have actual knowledge that you are committing a fraud, but if you don't, but if you're reading, if you can go back and now look at the statute and manufacture a reason and says, well, that is objectively unreasonable. And therefore, I can't be reckless. And because I can't be reckless, I don't have Sienna, so I don't have a false claim.
Well, to begin with,
is that what you're saying?
I'm saying that you don't inquire into subjective mens rea. But in any event, I think that you can look at, we said in 2006 what our interpretation.
Let's make sure you're speaking directly to me, and I understand we can use the legal terms of mens rea, subjectivity, and objectivity. I'm saying dealing with the factual scenario where one has actual knowledge of a fraud. Let's assume that is the fact, which we don't have to assume it. It's right here. You got it right here from CMCS. That puts out his rule, your client disagrees with it, does a data audit, does it for nearly everybody, but then picks these favorite ones to not doing it. That's knowledge. So they know it. Your position is, forget that, look at the statute and see if this reason is something that you can't say is objectively unreasonable, a term that sort of we pull out of some court, maybe Safeco use it in a position in the instance of the Fair Credit Reporting Act, all well and good. But they did say context is important. So in this context, how do you make that case here?
Your Honor, it is because you can't have, and this is a point that the super value decision from the Seventh Circuit made, when the law is objectively, your interpretation is objectively reasonable, you haven't been warned away by an authoritative interpretation, you can't say you actually know. Secondly, I wanted to say that on page 25 to 26, and again in page 14 of their reply, and that's of their opposition at the district court, and at page 14, note 6 of their reply brief in this court, relators, I think, concede the fact, or they waived essentially this argument that there are other layers of mens rea. Their entire argument below was basically was the objective reasonableness argument, which they agreed was the governing test. They agreed on page 24. And so, you know, I don't think you need to get to it as a general matter.
But in any event, let's be clear, make sure we center ourselves to understand what the law is. We're on the 12B6 and we're dealing with plausibility. Is that correct?
And I think
absolutely, it's correct. Yes. I probably shouldn't ask the question. It is correct. We're here on the 12B6 and it's a plausibility determination. And that factors into what we're doing here, right?
But as a legal matter, all you have to do is say, is it objectively reasonable? And I think that we do have an objective reasonableness standard. I also want to point out that the reasonableness standard is baked right into the regulations and into the rebate agreement. It says, if there's not something on point, you just have to be a reasonable assumption. It invites reasonable assumptions and average price calculations and best price calculations. If I could get to this question about whether CMS actually really ruled on this, I want to point out this is where Mr. Dos Santos began his talk. It's at page 72 Federal Register 39198. It is the point that they were making there was they said both this would effectively call for combining two separate prices, one offered to a PBM pharmacy benefits manager and the other to a customer of a PBM. Then followed what he actually read about, what he read about how, you know, we have a separate price for everyone. And they say, we do not agree with that comment, but he didn't read this part. Although we have deleted the requirement that manufacturers include PBM rebates and discounts and other price concessions in best price, there are instances where some PBM rebates and discounts may be designed to adjust prices at the retailer or provider level. So they didn't specifically disagree with our idea that you look to the actual price the party received. That's all we're talking about is just like the statute says, it's a price from a wholesaler
Mr. Elwood,
to a party.
Mr. Elwood, I wanted to, my friend Judge Wynn has said, well, the companies can get off the hook by saying, just look, this is objectively reasonable. Well, the company on its own motion can't get off the hook that way. The objectively reasonable test has got to be something that stands up in court. That's objectively reasonable. The position has got to be something objectively reasonable, has got to be something that a court finds. And if a claimant under the FCA is proceeding on dubious grounds, is taking a terrible chance that the court's going to find it not to be objectively reasonable. And so the objectively reasonable test, if I were an attorney advising a company, I would say you better make darn sure that our position here holds water and that it's an objectively reasonable test. And if we come up with something that's half-baked, we're going to get slammed for a whole lot of damages. So I just don't think that, you know, the idea that the objectively reasonable standard is some kind of gift to companies and let them get away with all kinds of fraud, it just isn't the way it plays out in actuality. They're still going to be very risk averse in what they're claiming and on what basis. That's all I'm saying.
May I answer, Your Honor?
Yeah.
Precisely correct. And I think it's also telling that, you know, this isn't something we just cooked up now. This is what we said in our 2007 comment letters. It's what.
But does that matter? Does that matter based upon the way you're proceeding here? Let me tell you, let me put it in terms of this. Let's assume that you knew you were violating the law at the time. And then you then challenged on it. Then you go look at the statute and you say, well, what you did, there's an objective, reasonable basis for doing so. Even though you intended fraud and knew you were doing it wrong from the beginning, and now after the fact, you come up with the reason as to what that would support what you did, even though whether you did or did not, it comes after. So that's what I'm saying. It doesn't matter whether you manufactured it yourself, but the outcome is that you can do it. You can come up with a reason. And if the court finds, based upon its interpretation, its own means of going beyond what Congress and what the statute says, oh, it's not objectively unreasonable what you come up with, you're off the hook. Even though in the first instance, when you started out, you knew you were violating the law. Is that the position?
Your Honor, I think that I would say that you can't really know what the law is if the law is so unclear that you can have literally an objectively reasonable position that you're right. That's what the super value case.
But what difference does it make? What difference does it make? If you start out with the intent that you know, even if you know what the law is, and you even, everybody's looking and says, the law says this, and you say, I'm gonna do it, and you're committing fraud. I know I'm doing fraud. And then when you get called out on the carpet for it, you say, you go back, look at the statute, and says, wait a minute. If you read this statute, there's an objective, reasonable basis for me to do it. So I'm free.
Your Honor, just as in the Justice Scalia's Gates and Fox case cited at page 43 of our brief, if the law is so unclear that you know somebody can come along later and say, oh, look at this. This can be objectively interpreted to mean something completely different where your conduct is lawful. That is a real due process problem. You can't say somebody is a guilty.
Well, even with the due process problem, go back to CMS issued this rule. Your client disagreed with it. And then you did your data audit. And after you do this data audit, you then eliminate all those scenarios that would put this contract in that vein. And then you create this favorite customer, and you know, you have to know because you disagreed with it. You knew what they said there. And at that point, you know what you're doing is not in compliance with it. Why is that not knowledge? But you're saying, okay, I knew and I did it, but guess what? I'm going to go and ask the court to look at the statute and say, well, what I did is objectively reasonable, and therefore I can get away with it.
Your Honor, STAFO begins from a threshold of ambiguity. And if the statute is ambiguous, I don't think you can really say, oh, I knew that what I was doing.
You know, we could talk about SACO. We've been there. My position is you have to look at it in context. I think the Supreme Court says it. We have some differences of opinion. Other courts have said it. They can say it 1,000 times. It's right there. There's such a thing called textualism. There's such a thing as called we are going to be consistent in our cases and how we handle them. So I got the SACO aspect of what I gave you was specific facts from this case.
I'm trying to get
the facts of this case, but I want to give it to you again. There's a rule here, and the rule is made, and you disagree with it. You then do your little research, your data audit. You then cut out those scenarios, and you save them for a few favorite customers. That's the problem in this case, is you knew you were doing it.
Your Honor, if I could read this is the district court's, and I agree with the district court's interpretation. Relator has not pointed to a single example where CMS explicitly states that manufacturers must aggregate discounts to different customers along the supply chain in a given sale. Their rule did not disagree with us. There was language in the preamble which we said was ambiguous, but it could be interpreted that way. And we said that our interpretation was, and this wasn't just us, this was us and many or most pharmaceutical manufacturers. Our interpretation.
I'm accepting everything you say being true, even with the district court. But the first instance of it is to know is the actual knowledge that you are doing something that is inviolative of the law. To know that, but then that the statute could have. But let's assume it can have this reading. Is what you did was not objectively unreasonable, and so it just invites opportunities for entities who are in violation of the False Claims Act by actual knowledge to then go and search this statute, get you some good lawyers and find a good court, and then till you find something that says it's objectively, not objectively unreasonable.
Your
and
Honor,
therefore, we can throw out all of what Congress wanted to do when it wanted to broaden this whole statute to say, we are not going to let you commit fraud against the American people by enacting this Fraudulent Claims Act.
Your Honor, it's due process 101 that if the statute is
it may be due process 101, but the facts of this case is due process.
Can I just hear his answer? I want to come back to your point, but can I hear his answer? I totally want to hear his answer.
It's due process 101 that if a statute is ambiguous and it's not clear what it prohibits, you can't hold us guilty of violating it. You can't say hold us subject to treble damages for that. That is due process 101, Gates and Fox. And in addition to that,
well, I want to make sure Judge Richardson asked for a response. Did you get something out of that, Judge Richardson? I'm trying to, because I didn't. I'm not understanding the due process.
I just wanted to hear his answer. That's all. I got his answer.
It was probably the use of the due process 101. I'd like for him to point to some case law on it that really goes to it. And I understand your argument, case law. Not being, I understand it's basic law. And you know, I can deal with that, but that's where I was going with it. I wanted you to answer the specific example I gave here with the facts here. We can talk due process 01, we can talk about civil procedure, we can talk about safe code, everything, but here's the example. Actual knowledge based upon the conduct here.
May I answer?
Yes, please.
The point is, we said, and everybody else in the industry said, we interpret this regulation to mean you only collect together discounts to particular entities. We said that the government, if they were going to disagree with us, that was the time to do that. The government talks a lot about post hoc interpretations. It didn't clearly say, you know, you have to collect together every discount you give to every actor. They could have said that. That would have been the perfect thing for them to say if they meant that in 2007. Instead, fast forward 15 years to now. Did they say that in the district court? No. They say that for the first time in a court of appeals pleading here. That's the first time they say unambiguously, you got to collect together all of these things. So, I mean, if there's a problem with post hoc rationalizations, it's on the other side of the V. And I'd say that, again, Gates and Fox says that if you can't hold somebody culpable for unexpressed intentions, you got to put it out there in black and white. And
all right, thank you, Mr. Bell. We've given you a good bit of extra time because of that question. I want to thank you very much.
Thank you, Your Honor.
For your argument. Is Mr. Callow or Mr. Dos Santos up next? Some of you had some rebuttal time. Who's up next?
Yes, Your Honor, Mr. Dos Santos. Your Honor, I do want to emphasize the allegations here and the fact that we're at the pleading stage.
Can I ask you maybe the same question to make sure that I understand the government's position? Is actual knowledge of an agency position, hypothetical, whether there's an actual knowledge of agency position, is that the same thing in your mind as actual knowledge of the law? So the agency's position becomes the law in your perspective? Or is there a distinction between those two?
Yes, Your Honor. In this context, the defendant was required to follow the binding regulation. Rebate agreement requires it to follow CMS's regulations and interpretations of the statute. The allegation here, and I want to make this clear, is that...
but I understand, but you just make sure I'm answering the question right. The question, I'm talking about scienter, right? And so knowledge of the law, right, is one question. Knowledge of the agency's position is a separate question, right? And I'm trying to understand, in your position, is your view that they are the same? That if you have knowledge of the agency's position on what the law means, that is the same thing as having actual knowledge of the law?
So as to actual knowledge, if you know the agency's position and you're submitting a report to the agency about what your best price is, and you know the agency is going to interpret it a certain way, it's going to believe that what you meant by that was that you were aggregating all discounts. You know you are submitting misleading information. You know you were submitting a false.
And is that true even if it turns out that the agency is wrong?
If it turns out that the agency is wrong, then you don't have falsity. But as the Eighth Circuit in Alina said, if you know that the government is interpreting a certain way, it is misleading for you to submit information while recklessly disregarding that. And that comes straight from the common law of fraudulent misrepresentation. I just want to emphasize here, just at a very high level, the allegations here are that the defendant submitted a letter in 2006 saying, hey, your proposed rule seems to be requiring us to do this. Then CMS issued the 2007 rule, did not say what the defendant wanted, instead said, here's an interpretation that was offered in the comments. We don't agree with that. Provided two examples of where discounts need to be aggregated. And then the complaint says there were board meetings about the fact that the company might be violating best price. And then
Does any kind of comment, does a letter from the IRS or any kind of comment, that doesn't have the formal status of law, a CMS comment?
Your Honor, here we're dealing with a notice and comment regulation. Now, as to what can place a defendant on notice, as to the high likelihood of a violation, which is what the court said is required in Drakeford and in Mallory, it said all that you need to show is that the defendant was deliberately ignorant, that it was treading on thin legal ice. That can take many shapes. In Drakeford and in Mallory, it was attorneys who warned them and said, these contracts don't seem to be complying with the Stark Law or with the anti-kickback.
No, it's very interesting that we have this rule of lenity with respect to the vagueness of statutes, and people are saying, well, this statute is vague and therefore it's a violation of due process, and all of a sudden vagueness kind of goes out the window when we're talking about this. What I'm wondering is, it seems to me that there is a great deal of difference between factual fraud, where you're claiming something that is not true as a matter of fact, and something that is a disputed legal question, which can be disputed ad infinitum and argued among lawyers. And the question is, if the agency takes a certain position, then it may be in court that position holds up as objectively reasonable, or it may be in court that it does not. It seems to me that the agency's position adds to the calculus of risk that a company would be taking and going against it, but it would not, on that account, necessarily make the company's view objectively unreasonable.
So, Your Honor, in this context, the rebate agreement is clear that manufacturers need to play by CMS's rules. The defendant is agreeing to abide by CMS regulations.
But isn't that different from a formal regulation?
No, the rebate agreement applies just like a statute of regulation. The Supreme Court made that clear in the Astracare case. But fundamentally, Your Honor, the allegation here is that the defendant told CMS, we don't agree with what you're saying in the proposed rule. CMS gave it an answer that it didn't like and then just ignored it. It could have challenged it in court. It could have gone back to CMS. CMS has a policy inbox, and it could have said, CMS, please address this. We think that you're wrong. Those are questions that can be addressed at a later stage of the case. Defendant might have evidence later on showing that it was acting in good faith. We relied on our counsel. We did discuss with industry experts, and we concluded that we were in the right. But the allegation here is CMS said something that the defendant didn't want to hear, and then the defendant just ignored it.
You mean that there can be no challenge, no matter how unreasonable, to the position taken by the administrative state, that is the altar before which we all must bow.
You can certainly challenge it in court.
I think what's happening is that the administrative interpretation may be brought up in a court of law as saying this makes this position objectively unreasonable. Fine, but the idea that this is the final and definitive rule is troubling, particularly if the statute reads very differently.
Let me
is ultimately the final arbiter.
Let me be clear. The defendant could have challenged CMS's rule in court, but under this court's cases in Drakeford and Mallory, as to the knowledge component of deliberate ignorance, which is not objective reasonableness, that is a separate statutory element.
That's the whole crux of this line of questioning. I mean, we're not dealing with the Siena here, we're dealing with the agency's interpretation of the statute is the law. If you want to challenge that, you can challenge it, but to challenge it by just disobeying it and doing something different would have chaos throughout the industry. You'd say every time an agency makes a law, if you can find yourself a reasonable interpretation of the statute other than what the agency got here, you go do that and just ignore this rule that has been made in accordance with Congress. That's what Drakeford has set forth here. And so when CMS makes this rule, what makes this particularly egregious, it's not a situation where they just read it and said, well, we're going to do something different. They actually went back and disagreed with CMS. So they knew the position that the agency took. And yet they engaged in conduct with these favorite customers that was directly in contravention with the rule. If that's the law, we are setting up a situation where an agency's rule, once you make it, you can go there and argue and disagree and put up everything you want and come up and says, I'm going to do something different because now I read the statute differently. That's not the way you challenge it. You can challenge the agency's regulation, but you don't do so with actual knowledge of a fraud for what the agency has set forth.
May I respond briefly, Honor?
Yeah, you asked for 5 minutes and then, you go on and on. We've had 6.5 minutes in addition to the time that you asked for. We have to have these come up with litigants that ask for 1 or 2 minutes and then they expand it. Go ahead and respond.
So very briefly, Your Honor, I agree. I think that Drakeford sets out the test as being, if you're deliberately ignorant that you're treading on thin legal ice, that's enough. And the contrary position would really be sweeping because in all of these cases involving contexts like these defendants say, it wasn't clear. Thank you, Your Honors.
Thank you. Mr. Keller, do you have some rebuttal time?
I do, Your Honor, and I'm going to try to answer your question. I appreciate what Judge Wynn has said about Safeco and the analysis, and I can't say it any more articulately, but I do want to talk about your question to me on Safeco and this objectively reasonable approach, Your Honor, because my question back would be, what did this company do in 2007 when CMS published that preamble and said to stack? And Mr. Elwood is saying, oh, well, we just went about our business.
Right, and it takes a greater chance in court if it acts on that basis.
Right.
But, the agency, it's instructive, but in many cases, the statute itself is ambiguous, and in many other cases, if they fail to follow an agency interpretation, that's something they're going to have to answer to the court about. But just in this particular case, the statutory language is so clear.
So, Your Honor, even if we assume that the language was statutorily ambiguous, we know in 2007 that CMS told Allergan its interpretation. Did Allergan's counsel tell it, you have a problem here? Did Allergan's counsel said, ignore CMS because we're right? Did the board decide, as Judge Richardson said, well, we'll look at the statute and not the rules? Those are factual issues. We're assuming that Mr. Elwood is right because he said it in a brief. We don't know what happened in 2007 or 2005 or 2016 because we were denied this opportunity at the motion to dismiss stage to even talk about those issues. The district court said we have a plausible explanation on warned away. The district court specifically said you could read our guidance to say that the company was warned away and then ignored that plausible explanation at a motion to dismiss stage. These are factual issues of what the company did or didn't do, of what it understood. That has to be decided at the factual stage, not at a motion to dismiss stage.
Thank you, sir.
Thank you.
Are there any further questions?
I have none.
All right. We will, I want to thank counsel for their presentations, and we will head into the final case of the morning. Thanks to all three of you. We appreciate it very, very much.
Thank you, Your Honor.
Next case is 2020-80.
Good morning. May it please the court. For some reason, I'm not able to bring up the, let me try. Yeah, I got it now. All right. I represent the plaintiffs in the underlying case. In this case, the district court held as a matter of law that a 10% liquidated damages provision contained in the contractual documents governing an ERISA multi-employer welfare benefit plan was unenforceable because that provision exacted a penalty for late payment of contractually required contributions. The district court got there by applying what the district court euphemistically described as a principle of the federal common law. What the district court was alluding to is a rule of law that has been adopted by a number of federal courts in simple, typical, ordinary contract cases that holds that liquidated damages provisions that are penal in character are unenforceable. That's an old common law rule. It's actually embodied in a section of the Restatement of Contracts. It's based on years and years of state law principles that, again, developed in typical, ordinary contract cases. And it's driven, interestingly enough, by an underlying policy consideration in our law of contract that in cases of breach of contract, the remedy is supposed to be limited to compensatory, and there ought not to be a punitive element. Hence the rule that liquidated damages provisions, even though clear and unambiguous in the contract, are legally unenforceable. Respectfully, in this case, which was brought not as an ordinary contract case, but as a contract-based action under Section 301 of the Labor Management Relations Act, a very, very different policy imperative should have guided the court's formulation of the appropriate rule of federal common law. In cases going back to Teamsters versus Lucas Flower back in the 1960s, before Judge Wilkinson graduated from law school, it has been clear that when a federal district court is required to apply what we refer to as federal common law, what the federal court is tasked with is divining a principle of common law that is consistent with the underlying federal policy. In a labor case brought under Section 301 of the Labor Management Relations Act, in effect, what the court is tasked with doing is ascertaining what congressional policy may underlie the issue at hand. I'll admit that there are many instances where divining congressional policy is a difficult undertaking. In this case, it's not difficult at all. Congress made that very, very simple when it comes to liquidated penalties for belated contributions to employee welfare benefit plans.
Isn't the question here the degree to which Congress displaced the common law?
Well, absolutely. The common law has been totally displaced.
Well, it's been totally displaced, maybe with respect to unpaid contributions. But the question is, has it been totally displaced with respect to contributions that are just a little bit late?
Well, I think what Your Honor alludes to is that the ERISA remedy that was introduced in connection with the 1980 amendments to the statute is limited to contributions that happen not to have gotten paid by the time suits filed. I won't comment on the wisdom or lack thereof in limiting the statutory remedy in that manner. But what I'm addressing is a much broader, clear, but much broader articulation of congressional policy in connection with the 1980 amendments, in which it was made absolutely clear that there was concern not only about non-payment, but late payment.
Counsel, doesn't the specific control the general?
Well, I don't know that doctrine of interpretation applies here. This is not necessarily a question of statutory construction. The issue here is not whether the specific statutory remedy under 502G2 applies. This action was brought clearly under Section 301. The question here is that when fashioning an appropriate common law rule, not a statutory rule, but a common law rule,
well,
should the district court have been guided?
Counsel, please, if we're talking about a common law rule, isn't the common law rule what the district court set out?
I'm sorry, I'm a little hard of hearing and I could not hear the end of the question.
That's no problem at all, counsel. I have the same problem. I was going to say, isn't the common law rule what the district court set out? And said, well, which is the hub of it was, can you, the damages of the actual damages ascertainable?
I'm going to address that very thoroughly because I think that's important. What the district court was alluding to is, I think, what the district court perceived as a universally applicable body of common law principles, one of which was the idea that in contract cases generally, liquidated damages provisions that are too penal are unenforceable. I think that's a mistaken view. Again, this wasn't a typical contract case. This was a Section 301 case. What the district court ought to have done is ask the question, what principle of law could apply here that would be consistent with federal labor policy as articulated by Congress? And I don't think
you're opposing, counsel, you're opposing all of this at such a general level. And I don't understand why the question would not be, ERISA displays common law with respect to unpaid contributions. And with that, you can recover up to 20% of the unpaid contributions under 502G2. But you can recover under common law as well. If the amount of the damages is unascertainable. But the point is, there's a difference in the statute that all the Court of Appeals have recognized between unpaid contributions and contributions that are late. And I don't know why that would dictate the business here, because if they're just late, you go into the common law rule, and under common law, liquidated damages are disfavored and actual damages are preferred. And isn't that the way the majority of circuits have interpreted this? I mean, liquidated damages are almost, I mean, they're punitive, but they're even more than that because they're set. But the reason that they are disfavored is because in breach of contract claims, you normally like the breaching party to be liable for actual damages, but to say that actual damages may be very nominal, but that the liquidated damages that we're going to impose may be very steep. That goes against the thrust of the common law rule, which favors actual damages.
The point, I think that the clear answer is the common law rule has to give way in the labor area. And the answer is that the specific statutory remedy under 502G2 becomes unavailable if the payor, although way late, happens to get the check in before suit's filed. That relegates the fund to a common law, not a common law, but a Section 301 action for breach of contract. Now, I simply maintain that if Congress says that there is a mandatory, and I repeat, mandatory 20% liquidated penalty under 502G2, if we simply shift a little bit to a Section 301 case where the payment, although clearly late, happens to be made before suit's filed, it is incongruous in that case to say, well, not only is a liquidated, contractually mandated liquidated penalty not mandatory, but we're going to invalidate it completely. That to me is incongruent, and I would suggest that if the court examines this from the perspective that it's a 301 case, not a simple breach of contract case, the court will see that immediately. Let me add.
That seems to be your entire argument, that this ERISA provision for unpaid contributions and this provision for this 20% liquidated damages, and therefore they should be allowed, especially if they're less than 20%. Is that the only consideration you have for evaluating liquidated damages?
Well, the ERISA provision simply is the vehicle which allows us to perceive the congressional policy. So whether the statutory provision itself is not germane, because we're not operating under ERISA here, this is a Section 301 case. All the importance of the 1980 amendments is it gives us insight into Congress's thinking. And in the brief, we quote repeatedly from the congressional record when multiple sources commented on the problem of employers not making the required promised contributions on time, not making them at all, but making them on time. And I would challenge
isn't that legislative history as opposed to what was enacted?
It's, of course, the legislative history. What better source would we look to divine what Congress's policy concerns were?
Would be the statute.
If we were dealing with a statutory interpretation issue, but we're not. We're dealing with a question of congressional policy.
You sure fool me. I thought we were dealing with a statutory interpretation.
My apology. We're not. We're not construing 502G2 because we brought the action under 301. And 301 simply says to the district courts, or to the courts, formulate appropriate rules of federal common law. Our position is that when one does that in the labor area, when we have a congressional record, like we're lucky enough to have in connection with the 1980 amendments, where multiple sources condemn the practice of employers of not paying on time, that's policy. I'm sorry.
Counsel, please.
I hear myself and I can't hear anything else.
It's not a problem at all. I understand completely. The problem here is that the fund, not on the basis of a negotiated settlement, but on the basis of a provision that it added without any input from these defendants. And the fund is seeking $80,000 in liquidated damages, even though the actual harm was limited to a few lost interest payments. Now that doesn't strike me as right in the face of a statute that did not impose these kind of draconian penalties in this kind of situation. There's going to be a lot of companies that are a little bit late with their payments, and that differentiates those companies that fail to pay at all. And you're going to be only harming yourself if you clobber these companies with liquidated damages even though they paid, albeit in a tardy fashion, and their actual damage to the fund was minuscule. So you're going to cover the company with a huge liquidated award when your actual damage is absolutely minuscule? That doesn't, and you're going to do this on the basis of a provision that wasn't even negotiated, but that was inserted unilaterally?
I'm not going to respond based on what I think. I'm going to respond based on what Congress clearly thinks. Congress thinks that these companies need to make those payments on time. And we're not talking about with a payment that was a little bit late. We're talking about 17 payments that were late over a long period of time. And what I would suggest is if we as a fund can't use a liquidated penalty that's harsh to get the money paid on time, what can we do? Call them on the phone, plead with them, remind them of their contractual duty? These funds don't have a lot of mechanism to collect money. They're not like the power company that has collectors.
Well, what you can do is recover your actual damages.
Well, but that certainly doesn't incentivize employers to pay on time without being sued.
Well, you know what? That's an argument for Congress.
It is. Congress already answered it. If one looks at the congressional record from the 1980 amendments, Congress was very concerned with this problem.
Counsel, you're right. It answered it. It just answered it in a way that is adverse to your view.
I'm not sure that's true. I think the ultimate statute didn't provide us with a statutory right of action, but we have a contractual right of action. You know, and to say, well, it's just a little bit late, depends on how much you need the money, doesn't it?
I don't know. That's maybe a good subject for a rebuttal, but now, if we have no further questions, if either of you have any questions, Mr. Goodwin, we'd be happy to hear from you.
Thank you, Your Honor. May it please the court, my inclination is to submit our argument based on the reasoning of Judge Copenhaver's 44-page memorandum opinion. But I did want to point out a few matters. Of course, as the court has already pointed out, the issue before the court is whether the federal common law rule regarding punitive liquidated damages provisions applies to claims like this one brought pursuant to Section 301 of the Labor Management Relations Act. And Senior District Judge Copenhaver correctly answered that question in the affirmative. And Judge Copenhaver is not alone. While this court has not yet squarely decided the issue, the clear majority of the courts who have answered this question in the same way Judge Copenhaver did, as is evidenced by our long footnotes spanning pages 16 to 18 of our response brief. Appellants below acknowledge the applicability of the federal common law, as well as the two conditions for enforceability that challenged liquidated damages must meet. But what they try to do below is attempt to do what they're trying to do here, and in fact doubling down on, is diminish the potency of the federal common law's anti-penalty rule by pointing to an ERISA provision that might have permitted liquidated damages provisions like the one stated before by them. But critically, this is not an ERISA case. Appellants didn't sue under ERISA, nor could they. As the court's already correctly pointed out, the ERISA provision to which they point, Section 506G2, applies only to unpaid contributions. Nitro's contributions are not and were not unpaid. And they weren't just paid right before suit. They were late.
You say this is not an ERISA case, and I tend to agree with you, but one of the most distinguished judges of our generation has said that this is ERISA land. And I might just gently say, because I'm talking about someone for whom my admiration is profound, that saying this is ERISA land, a little bit loose. The statute is very precise on what it covers and what it doesn't.
Yes, I think Your Honor is obviously referring to the operating engineers versus Gustafson's case, authored by Judge Posner. And in that case, of course, it was in ERISA land. There was ERISA and Section 301 claims brought. That's not our case. We are not in ERISA land. And Judge Copenhaver correctly found that for claims brought under the LMRA for late contributions, Section 506G2's remedies do not apply, and contractual liquidated damages may be enforced only when they're not penalties under federal common law. If Congress wants to allow punitive liquidated damages provisions in the LMRA context as well, it could do that, but it hasn't done so. So appellants are now doubling down, admitting that the liquidated damages provisions at issue are punitive, but advocating for this court to craft a federal common law informed by Section 506G2 to permit the enforceability of such provisions.
Expand a bit on the operating engineer's case. I think as I recall, it really comes down to the fact that this is not an ordinary contract. This is dealing with a collective bargaining agreement. And when you delve into the rationale that was used in that case, it becomes clear, of course, 502 doesn't provide for the late contributions, but that term said the ban on liquidated damages should not extend into ERISA land, which basically is what Judge Wilkinson was alluding to. If we are in ERISA land, which means that it can be used as guidance for why it would be imported into this type of conversation, which because of the differences of contracts, that's essentially, where we are right now. If we are trying to ascertain congressional intent or to determine it in terms of the definition of the common law perspective, we cannot ignore that Congress itself has a certain way. I mean, there's really no reason. It looks like to me it would be a penalty under 502, but for ERISA. To not speak on it, but to demonstrate that the provision of liquidated damages is not a penalty in that context. At least it looks to me like operating engineers, is indicating, you can. These are not penalties in that kind of light. Just expand on that. Maybe help me to understand the import. Since that case came up, I want to understand this import here.
Sure. And I think that the result of the operating engineers case was really born from that court's perspective that the anti-penalty rule is somewhat antiquated, that parties, particularly sophisticated ones, should be able to agree on such provisions. But significantly, here, the method for calculating liquidated damages was derived not from arm's length negotiation between the parties, but by the unilateral selection of the appellants. I mean, the collective bargaining agreement.
But as I recall, it is less than the 20% that 502 has. What is the amount here? Is it 10% or so?
It is 10%, Your Honor, yes.
So, I mean, that's half of what Congress is allowed in that context. And if we are in this so-called ERISA land, I mean, that doesn't sound like to me it's that unreasonable.
Well, where it becomes exceptionally unreasonable, and the district court recognized this, is the parties didn't receive, or the appellee didn't receive notice of these until well after the fact, and they racked up very, very quickly. So I think, we likely wouldn't be here if we were able to get notice of those matters and matters quickly. So I hope I've answered your question.
So you're saying we ought to address this condition precedent of notice provisions for liquidated damages?
Well, I don't know that you have to get there, Your Honor, but that is an underlying fact here. Yes, Your Honor.
I mean, it seems like your answer hinged upon the fact you didn't know about this, and the question then arises: is that the notice? Is that a condition precedent for liquidated damage to have, notice of?
Well, Your Honor, I believe that you should have notice. However, the court need not get there. The liquidated damages provision, as evaluated by Judge Copenhaver and evaluated quite cogently, is actually and should be invalidated.
Let me just make sure I understand. So, because some things you can come right down to where the disagreement may, and you can disagree or not agree. And if the determination is a common law, and you don't look at any other provisions, whether ERISA or even the Labor Management Act or anything else, then that seems to favor your position. It's a penalty. But if you do go to those provisions and light of operating engineers that says, which is not controlling, but then says, you look here. If you want to see what Congress was thinking, look over here at this statute, which is just like the kind of thing here, just didn't have late penalties in there, and you get guidance for it. So if it's that demarcation, you're there. If one is on this side looking at the rest of it, you're going to go a different way. If you're on common law, you're going there. So it's a matter of choice.
But Your Honor, even if you do look at ERISA, it was for unpaid contributions. Here,
well, and that would follow if they were seeking damage on the 502, and it's clear they're not. They're doing it on the 301, and now you're trying to determine, can you get these? And so you go back and you look at ERISA to do it, and the question is, can you do that? Or should you just go to common law? At least that's the way I see it. I'm just trying to posture what the issue here, and then the choice is made. I mean, as to which way you go on it. So it sounds like to me your choice is you don't need to look at ERISA because the common law tells you what to do, and that's the end of it.
It does. And if this court has consistently applied the common law in the LMRA context. It just hasn't yet had the opportunity to do so in the context of an evaluation of a liquidated damages provision. So Judge Copenhaver, when looking at this matter, said, okay, I'm to apply the common law. The common law finds that liquidated damages that are penalties or penal in nature are unenforceable. And then we need to look at the two-part test. And in this case, appellants didn't even try to meet the two-part test for enforceability. Rather, they try to pull in this inapplicable ERISA-based test and say it's necessary to make sure that they get paid. Well, it certainly wasn't necessary in this case because they were paid. But I think what they want is the ability to, in fact, impose this penalty or windfall if an employer happens to be a couple days or a couple minutes late, even though they end up $0 short.
So how do we deal with situations where it's not a couple of days or a couple of minutes, but an instance of what we're actually dealing with, multiple instances of it for a period of time, and then the idea being is, well, yeah, you can get actual damages, but if that's all you're going to get, there's no incentive for you to do anything. Those actual damages aren't going to be that much. I mean, if you don't have something like a liquidated penalty there, if you are viewing it in the ERISA perspective as to where you go, and you had mentioned, I was trying to figure out this notice thing in the due process, I guess, at least of you're not part of the negotiations, but even the district court recognized that notice was a material fact that was disputed here, whether it was sent and received, and so that kind of takes us a different place. And I know you're not hanging your case on that. Right. So how do we do that?
Well, I think that so your question is how do we ensure that the parties do? I mean, well, in this case, in
the instance of your client in particular, multiple times. I mean, how many times was it? Was it 14, 16, 17? I can't remember the number of times, but it was more than one or two times, and more than a few minutes. And I got that point. That seems to be there. But it seems like at some point in time, something ought to happen. There ought to be some reasonableness here that allows them to undertake some enforcement provision where it is in a collective bargaining agreement. And even though you may want to use ordinary, go into the common law or ordinary tax, but it is a collective bargaining agreement.
It is, but
and I might add just that when you're talking about collective bargaining, I mean, you can ignore it, ERISA, but a collective bargaining agreement has all kinds of restraints and impositions on it. It's not an ordinary contract at all. And maybe that's where Judge Poston was going with this thing. He said, this is not the same stuff we're dealing with something totally different here. And this is, as I understand, this fund is to fund monies to pay for benefits and other things there. And if you don't pay it, there's some serious consequence of what can happen, I would think.
There's no question that collective bargaining agreements are important. The situation here, though, is the collective bargaining agreement referred to the fund's trust documents, which in turn promulgated the delinquent employers' procedures. Only those documents, 2 steps removed from the collective bargaining agreements, had this liquidated damages figure in there. It was not something that was negotiated back and forth at arm's length, in the collective bargaining agreement itself. So, I mean, absolutely, collective bargaining agreements were and are incredibly important documents. There's no question about that. But where here, the actual provisions that the fund is relying on are a couple steps removed from those collective bargaining agreements that Nitro was a party to.
Is there anything further, Mr. Goodwin? Or
Not unless the court has any further questions.
Judge Wynn, do you have further questions of Mr. Goodwin?
I have no other questions.
Judge Wynn. No, thank you very much, Mr. Goodwin. We appreciate it.
Thank you, Your Honors.
Mr. Levikoff, you have some rebuttal time.
I believe I have 3 minutes, and I have 3 points to make. I'm going to try to relegate a minute to each of them. The first point is we've had some discussion about Judge Posner's well-written decision in Operating Engineers versus Gustafson. It's very clear. The court was addressing both statutory claims that did cognize under Section 502G2 of ERISA, but also contractual claims based on the provisions of the collective bargaining agreement. And the court specifically made clear that those contractual claims were contract claims under Section 301 of the LMRA, simply because, like here, the money had been paid before suit was filed. So they were purely contract-based claims for liquidated damages. Nonetheless, because it's all part of ERISA land, as Judge Wynn observed, the common law rule.
Not my word, Judge Posner's word, okay?
Exactly right, and well chosen too. The regular rule just didn't apply. Second point, there was some remark about the provisions of the collective bargaining agreement here not being negotiated. There were a couple of cardinal principles that really signify the different treatment that federal law applies in a collective bargaining situation than it typically applies to typical contract cases. And one of them is the language of the collective bargaining agreement governs. No ifs, ands, or buts, because everyone has to be able to rely on it. So to look at this penalty provision that is clearly in the governing documents and say, well, that's not fair because we didn't negotiate it. That itself is contrary to fundamental labor law. Here's the third point, the two-part test. Well, of course, we're not arguing about the two-part test. Our fundamental position in this case is that the two-part test is devoted to figuring out which liquidated damages provisions are penal and which ones aren't. Our position is not only should those provisions not be invalidated when they're penal, our position is they ought to be enforced purely because they are penal. Because if we don't have a penalty provision, employers in these multi-employer plans will do exactly what Nitro did here. Pay when they feel like it and just make sure they get the check in before they get served with a complaint. Thank you.
All right, we thank you, sir. And thank you as well, Mr. Goodwin. We appreciate your argument. Sorry we can't shake your hands, but I think you know why. And I hope you both have a very pleasant afternoon. Thank you so much.
Thank you.
Thank you so much.
I will ask the courtroom deputy to adjourn court until, I guess, tomorrow morning.
This honorable court stands adjourned until 2 p.m. God save the United States and this honorable court.
Thank you all.
Judges, I'm going to put you into the